Well, Henshaw here again, Constitutional Crisis Channel, another in our series of current events, although you won't read about this one yet in the newspapers, but trust me, I think before it's over you will, and that's the Miracle Merced case that gets better and better by the day. I don't know what the hell these people are doing out there. But as you know, those of you who've seen earlier videos, they sent me a blank form, in effect, that was signed by a deputy clerk refusing to file documents in that case, which included a demand for a bill of particulars, to which, if you don't know, and they apparently didn't know, there's a right secured by the Constitution to know the nature and cause of the accusation, the elements of the crime, the identity of your accuser, and a lot more things. But that apparently went right over the heads of everybody out there, and I get this blank form that you've seen on the video. And when I saw that, one of the first things I did was draft a letter to the Chief Justice here of the California Supreme Court, Connie Cantil-Sequoia, and the other justices who are all members of the California quote-unquote Judicial Council, of which the Chief Justice is the nominal head. Now I'm going to read my letter, which is something I don't do on videos too much, but it's important here, and I'm going to read you their response, quote-unquote, and you tell me. And by the way, both of these documents will be available. Check the bottom here. We'll make them available to you by email, those that request them, and see if you can sort it out. I'll be damned after 4 decades if I can. So the letter goes to the Chief Justice. I have just witnessed a stunning, summary, ex parte 12b6 denial, quote-unquote, of rights secured by the Constitution by a deputy clerk of, quote-unquote, court of a type I've never seen in 4 decades, which includes my recent, quote-unquote, vacation in South Carolina for 7 months as a political prisoner, and can only conclude that the court executive officer was given either very poor training or none at all by the responsible party, which facilitated the events described in my letters to the officials out in Merced. And the form in question, which I attached, looks suspiciously like one which might be, but has not been promulgated by the California quote-unquote Judicial Council, which would not in any event comport with multiple provisions of the Constitution for the United States, 1787 to 1791, and or the California Constitution of 1849, which remains in full force and effect. My principal concern is how this form, quote-unquote, notice of receipt of recent communication, could possibly be construed in such a way as to deny filings of documents presented by a quote-unquote pesky pro-per litigant with the naked, unsupported assertion that, quote-unquote, your request has been denied. By whom, for what reason, and what limits there any hearing and decision on the record here? When we all know that the accused has the right to appear, challenge jurisdiction, and in general invoke rights secured by the Constitution. Here a demand for a bill of particulars, to be informed of the nature and cause of the accusation, jurisdiction and venue of the trial court, elements of the crime, and other ancillary matters. Goes on. Having supervisory authority over the quote-unquote Judicial Council, yet another alphabet agency composed of trustees of the trust, whose rules, regulations, forms, etc. do not apply to at least a member of the sovereign body politic of the nation and republic, aka lawful de jure jus sanguinis state citizens, aka beneficiaries of the trust known as the United States. It seems like the chaotic quest to find a responsible party has ended, and it is earnestly hoped that any and all subordinate personnel will be promptly notified that this forum, assuming arguendo, its limited application, cannot and should not be applied as it was in this case, unless in the alternative all departments of the de facto California government are saying in no uncertain terms that any and all documents presented by pro-per litigants are res ipsa loquitur, that means it's a legal way of saying it, they're on their face, quote-unquote, specious, frivolous, and without merit, no matter which rights secured by the Constitution are involved, notwithstanding the absolute absence of opposition from prosecutors having at least the constructive oath of office to provide some, not to mention preserve, protect, and defend, quote unquote, this Constitution, and without the accused having any notice or opportunity to be heard on the record in his own defense. This is true of forgery, which means even more so in the instant case, since further documents have by now arrived at the trial quote-unquote court, including a motion to quash a petition for non-statutory writ of federal habeas corpus, and this in a final attempt to secure the right of notice and opportunity to defend in a case which should by now have received a sua sponte dismissal of all charges with prejudice to the cause. Your prompt attention to this matter will be expected. And they did, by the way, fairly promptly respond to this. But this is the letter I get back, not from the Chief Justice, not from any of the justices of the court, from the court administrator. Dear Sir, your letter to the Chief Justice, dated August 12th, has been referred to this office for a reply. Neither the Chief Justice nor any Associate Justice nor the full court may give legal advice or assistance. Does that sound to you like what I was asking for in this letter? Goes on, as you may appreciate, the law limits the courts to hearing and deciding cases. The courts may not otherwise participate in any matter that will be related to a current or future legal proceeding. I regret we cannot be any further help to you. You may wish to consult an attorney instead. Now, if you don't know, I'm 20-0 against those bastards. What do I need to consult with one of them for, number one? Number two, if you consult with an attorney and he appears in court, that's a general appearance. So you can't do that either, although I'm working on that. I may have some news in that area, but I'm still maintaining that position at the present time. And number three, if you have an attorney and you get convicted, and I'll do a fuller video on this later, but you get convicted, and I swear that this is true, that we have a guy in Texas that got convicted in a capital case and the death penalty was imposed, and he went up to the United States Circuit Court of Appeals for the Fifth Circuit, which is where Texas is, and complained about ineffective assistance because his counsel slept through a large part of the trial proceedings. The Fifth Circuit Court of Appeals said, in effect, that did not constitute ineffective assistance of counsel. Now, that's the only issue these bastards think is even worth the darn as far as getting up there on appeals and writs of habeas corpus. If counsel can sleep through the trial, and in fact, I think one of the justices that dissented in this case says, well, it looks like to me that the test for effective assistance of counsel is that you hold up a mirror to the defense counsel at the table while he's sitting there at the trial. If you can see him breathe on it, that's effective assistance. I mean, my God. Name is Burdine versus Johnson, by the way. I'll get you the site. It'll be down below here. It's out of the Fifth Circuit Court. And I'm going to have a case number and a date of decision. There is not a formal site that I can find, but you're going to get this one and take a look at it, and we're going to have a video on it later. But this kind of nonsense, and by the way, I addressed this letter to the Chief Justice in her capacity as head of the California, quote-unquote, Judicial Council. Not as the Chief Justice of the Supreme Court. Those are two different positions altogether. And if she's at the head of the agency that did this, and they're using this form apparently on her instructions, that's what I was trying to say. What the hell are you people doing in that capacity? Could you explain this, please? You've seen what's happened in this case already. And between you and me, I think what's happened is that they got a call out there in Merced, San Francisco and said, get the hell rid of this case. A lot like what probably happened in Columbia, South Carolina, when I sent an original writ of habeas corpus to the Supreme Court in Washington, D.C. They, too, probably got a phone call that hastened my release from there. So we'll see how that part plays out. I don't know yet. This is still an ongoing case, but we're going to come out of this, my goodness, it's smelling like a proverbial rose here. So that said, this is the kind of crap you get here. And if this is what they're saying, no matter what we do, no matter how well we do it, it's specious, frivolous, and without merit, we're incompetent, and therefore they can throw this stuff out without even filing it. When you see the brief I have, those of you that get my documents, and what the Supreme Court has said about this, it's completely the opposite, and it should be. That said, we'll revisit this Merced case when more events happen, and they will, and I'll get you up to date. Oh, one last note about this, by the way. I did try to call some people out there this week, because there's a tentative appearance date of next Tuesday after Labor Day. And I told my friend, I said, sweetie, don't worry, you've already appeared just like you promised to do with a government gun to your head. Because we tried to put in documents and tried to assert rights secured by the Constitution. And if they now issue an arrest warrant for a quote-unquote willful failure to appear, a lot of people might be in a lot of trouble out there for treason to the Constitution. Because she did everything that she said she would do. And by the way, getting back to the phone business, it took a couple of 3 days to get through on the phone system out there, which I didn't know until this week had been designed by Rube Goldberg. I mean, it was that bad. So I'm waiting to hear back. I put a message on there at the office of the Superior Court Executive Officer asking for the status of the case. We're waiting to hear back about that now. I think the charges have been dismissed, but I don't know that for a fact right now. You'll get an update when I do. Continuing the update video on the Merced activities. First thing is, we're going to put a couple of documents in the video. You can see them as the video is going on here. The documents, I just read you both of them. And the copies will be available by email to those who request them. That said, it also occurred to me, and I didn't mention it in this letter to the Chief Justice, and I should have, but here's where we might have some real play here, especially with federal prosecutors, because you have Federal Rules of Civil Procedure, Rule 5, and it says right in there that the clerk shall not refuse to file documents because they are not in the proper form. Now, where I come from, since we're raising federal questions, then the Federal Rules of Civil Procedure not only apply, they preempt, for example, the California Rules of Court, the local rules of court that the counties promulgate, and you name it. Everything is out the window. It doesn't count because we have a right of free access to the federal courts. Among other decisions in which the Supreme Court has said that is Missouri Railroad versus Larabee, Larabee, 234 U.S. 459. So they're going to try to keep us out of court, and using the rules like this to try to do it. The Supreme Court is not going to find in their favor if and when our cases get there, and this may be a powerful way to do just that. Number two, you put a lot of pressure on the clerks of court, quote-unquote court, when you bring documents in, and I would do this with the witness, and have a hard copy or two of this federal rules you can get from me, and if you request it, I'll send you that by email. 2 pages, it's a truncated version, but it has the appropriate things in there. And you say to the clerk, if you don't file these documents, on advice of counsel, it looks like to me we're going to have a criminal action against you, and I would much prefer not to do that. So that said, this may immediately get you much higher in the food chain, perhaps in California, to the executive officer of the Superior Court, and maybe even the presiding judge. And those bastards don't see anybody. And that's long been a boiling point for me, is that they should have at least one Friday a month, where they sit there in the afternoon and have hours where pesky pro litigants can come in there and ask questions like this and get answers to it. Okay, so they miss a tea time a month. What the hell? They're getting paid good money here. They should be taking care of business, and that would be the way to do it. So there's FRCP 5, and I'm telling you, I've got more authority on this as well. With major federal cases, and they're keeping us out of the courts. And this raises issues about separation of powers, about state versus territory. I mean, this is Pandora's box with an issue like this. It's that big. Just a little old rule of court, and look at what happens here. So anybody, any of you that want, copies of this stuff, let me know. Email me at ccaspari@live.com. And I'll get things to you and read the documents. You'll see them on the screen here. And you make your own decisions about what's going on here and why. But these are effective tools, and I hope you'll be able to use them well in your own cases. Thank you.